Honourable Milady. We're on issue 2, the indirect route, which depends on Article 3. I identified at the outset that we had 3 arguments as to why the Court of Appeal was wrong to find that the learned friends could rely on issue Article 3 by way of an indirect route through which to require the English court to recognise the effect of the December decision. Can I then just turn to the first of those arguments, which was what we've been calling the guarantee trust point, and that is the contention that the December decision is not, in fact, capable of determining the effect of the August decision under Portuguese law because it is only temporarily or defeasibly binding. Our case on that is set out from paragraph 84 and following of our written case, page 213. Your Lordships and your Ladyship will have seen that the learned friends take an objection to us making these points. I'm going to make the point first and then deal with the objection just because it helps in terms of explaining why the objection to us taking the point is not founded, if I at least go through the point first. Can I ask the Court to go back to Article 3 of the Reorganisation Directive, so Authorities Bundle Volume 1, Tab 1, page 1226.
Sorry.
1226. 1226.
Bundle.
Authorities Bundle 1. And can I, the Court has seen this, and can I make 2 preliminary observations about this article? And the first is this. Article 3, and in particular Article 3.2, is a provision that goes to choice of law and not jurisdiction. That's perhaps obvious from the heading itself. And since it is a provision about choice of law, the courts of each member state must give the reorganisation measure the effect that it has under the law designated by Article 3.2. That is to say, the law of the home member state. On the other hand, and this is the second observation, whilst one therefore is required to apply the law of the home member state, it is for the court of each member state before whom the issue arises to determine for itself what effect the reorganisation measure actually has under that law. And that is not a matter regulated by Article 3 at all. Rather, it is a matter for the procedure of the member state before whom the issue arises. By way of a note, can I give the Court a reference to the Advocate General in Kepler, paragraphs 72 and 73, Authorities Bundle Volume 1, Tab 6, page 1486, where this is a point which is made by the Advocate General in Kepler, that it is for the law of the home member state, that's to say the member state before whom the issue arises, applying its own procedural rules to determine for itself what the effect of the reorganisation measure actually has under the law of the home member state. And so a case under Article 3 is not different from any other case in which the English court has to determine the content of foreign law. And it will do so by applying the common law rules about how this should be done. And as highlighted in our written case, one such important common law rule is the guarantee trust principle. Now, can I first explain, I suspect the Court will be generally familiar with the principle, but perhaps I can say something about the principle itself, then say how we say it applies to the facts of this case. And then to deal with the 4 arguments which have been raised by my learned friends as to why they say the guarantee trust principle doesn't apply here. In terms of what the principle is that in making findings about the content of foreign law, English law is seeking to identify the answer that the Court of Final Appeal in the foreign country would give. And it is not bound by temporary or defeasible determinations in the foreign country. And we give an example of that in paragraph 88 of our written case. In that example, the state of the law of New York is considered in the English court, and it is represented by the likely appellate decision, not by the actual first instance decision. Now, I was proposing just to show the court guarantee trust itself in order to establish the principle, and perhaps I can just do that fairly quickly. Volume 1, tab 5, 1425.
And do we really need authority?
I hope not, my lord, because
I would have thought I think we're probably reasonably familiar with that.
I'm grateful. That authority has been followed by a number of other authorities. We identify the other authorities that have followed it in our written case, footnotes 111, 112, and 116 to 118. And I can also give you, the court, a reference to Briggs, Private International Law, paragraph 3.38. That's in volume 5 of the Authorities Bundle, tab 45, page 2857. And what the authorities establish is that the task of an English court, as I say, when seeking to determine the content of foreign court law, is to predict what the court of final appeal in the foreign country is likely to hold. And this means that the English court, which cannot form an independent view about foreign law, must seek to predict the foreign final appellate, what the view the foreign final appellate court is likely to form. And it also means that the court is not bound by any temporally or defeasibly determinations in the foreign country.
Well, that's in a different context in the present, though. In the present, we're asking whether there was jurisdiction at a particular date, aren't we? And if at a particular date there is a decision which binds the parties, you can't go behind that by saying, well, it might be set aside later.
Well, with respect, my lord, the question is, as under Article 3, is what is the what effect, or how does the laws of Portugal, which apply in the home member state, how do they give effect to or implement the August decision?
Yes, well, they've given effect and implemented them by a decision which may be avowedly temporary or provisional or subject to review, but is for the moment the legal position.
And when, which raises this question, let's assume, as I think we have to, because this is the English court has before it evidence which suggests that this decision is going to be overruled. What your lordship is positing to me is that in seeking to give effect to Portuguese law in terms of the effect that it gives the August decision, the English court has to give that provision an effect which it knows will ultimately not be what Portuguese law says about that decision. Because on the basis of the evidence before the English court can proceed on the basis that it will be overruled, and once it is overruled, it will become clear that that has never been the Portuguese law effect which is given to the August decision. And so in our respectful submission, regardless of the content, once one appreciates that what one is trying to understand is the Portuguese law as it affects the August decision, the December decision, if it is set aside, will never have represented Portuguese law. It may be binding on the parties, but with respect, the fact that it is binding on the parties is neither here nor there. If you go to guaranteed trust itself, the decision in guaranteed trust given by Noyes at first instance in the New York court was plainly binding on the parties. But it didn't, for the English court, represent the state of New York law. The state of New York law was represented by what the English court considered was likely to be the conclusion which a court of appeal in New York would arrive. And so regardless of the fact that it's binding on the parties, it does not represent Portuguese law. The position would be different if it gave rise to an estoppel or a res judicata.
Well, I mean, there's a difference, isn't there, between the state of Portuguese law as a general proposition and the question in whom was a particular asset or liability vested at a given date.
Well, your lordship says in whom was it vested, but once you get to the overall conclusion that the Portuguese Supreme Court will arrive at, in whom it was vested at a particular date will be that it was vested in Novo Banco, if we're right about what Portuguese law says. And if we're right that the first instance decision will be overruled.
Well, it won't be overruled retrospectively, will it? And even if it...
Well, it will. It will be, they will annul the December decision.
I see.
Once you annul the December decision, the effect of that is that the August decision will stand, and the August decision makes clear that the oak liability vests in Novo Banco.
I mean, there's a measure of artifice about the whole business of deciding matters as at a particular date. But then you yourself are relying on that in order to leave out of account the retransfer that occurred in September. If we have to ask what the position was at the commencement of the proceedings, as at that date, the December decision whatever its effects, was in force.
Will in force in Portugal. With respect, that doesn't help the English court at all to know whether it has to give it effect. It can only have effect if it's either a reorganisation measure or it is the way in which Portuguese law gives effect to the August decision, because all we're concerned about in issue 2 is the effect that the August decision has. If in fact the December decision, as a matter of Portuguese law, does not have any effect because it will be overruled, and just bear in mind it's on a question of fact, then that will always have been the position in Portugal. It will always have been the position in Portugal that the August decision was the only decision, as between the August and December decisions, which affects where the oak liability is vested, and the answer will be determined, as a matter of fact, as at the date the writ was issued, claim form was issued, on the basis that the oak liability was vested in Novo Banco. So although this arises in a different context, Lordship and your Ladyship will want to bear in mind that Article 3 is in fact simply a choice of law provision.
So if you have a national scheme of law designed to restructure banks and redistribute their assets and liabilities, and it contains a procedure which is provisional in its effect, the position as you submit it is that the English court is obliged to give effect to every other aspect of the scheme, but not this one.
With respect, no. It rather depends on whether what you're talking about, when you identify the provision which is provisional, constitutes a reorganisation measure in its own right, or can otherwise come within Article 3. And if there is no dispute that it represents the effect that Portuguese law gives to the reorganisation measure itself, then English law will have to give effect to it. I'm not disputing that English law must give the effect that Portuguese law gives to the August decision. The debate is what is the effect that Portuguese law gives to the August decision? Is it conclusively determined by the December decision so that the English court is bound to treat Portuguese law as represented by the December decision, even though on the basis of the evidence before the English court, that decision will be overruled, so that the position will always have been that the effect the August decision has is precisely as the August decision stated, and the December decision will not affect it at all. Because that's the proposition for which my learned friend has to contend. And we say that that simply cannot be the law. And it doesn't matter whether or not the decision of the Bank of Portugal is binding on the parties or not. And can I just give the court the example that, in fact, Mr. Howard gave in the Court of Appeal? What Mr. Howard said in the Court of Appeal was that between August and December, the position in terms of the effect the August decision had was at large. Well, we'd query that, but in any event, he then says, if you had a decision of a first instance court in Portugal, which gave effect, a particular effect to the August decision, the English court would be bound to give effect to that first instance decision. And he says the position where it's the Bank of Portugal making the decision rather than the first instance court in Portugal is no different. With respect, that is completely inconsistent with what Guarantee Trust says.
I think, yes. I mean, if Guarantee Trust, as I think you were saying a moment ago, actually deals with a situation where there was parallel litigation in the foreign country between the same parties, then perhaps it would be interesting to look at it on that point. You say, having briefly looked at it, I think it was the situation in some measure anyway.
It was,
yeah.
Which is exactly, I think it was at tab 5. Tab 5. Can I just very briefly identify the facts? The case concerned a claim arising out of a large-scale cotton fraud. A claim was made first in the New York court and then in the English court. And one of the issues in the English action was whether, as a matter of New York law, the bill of lading was conditional or unconditional. That very question had been considered in the New York litigation, and a New York judge at first instance, Justice Noyes, had decided that it was conditional. That decision did not give rise to any res judicata, just as the present decision doesn't, in the English court, but it was still a decision of the New York court. The question for the English court was whether it was conclusive as to what New York law actually was on the point, and all three judges said it wasn't. Lord Justice Pickford deals with this at page 1440.
Why didn't give rise to a res judicata or issue estoppel?
It appeared to have arisen as a demurrer in New York law, and for that reason it appears most clear in the decision of Mr. Justice Bailey H. at first instance, but it's not completely clear, but it didn't give rise to a res judicata.
Well, then perhaps it's not right, yes.
Mr. Salter says that's the point, and indeed that is the point, because in this case also there is no res judicata. Page 638, beginning after careful consideration of the evidence, I have no...
Well, this case doesn't give rise to res judicata because it's not adjudication by the authority.
It's not
whereas, and it appears the same applies here. Yes, anyway, carry on.
So, well, it wasn't by a court here. So, 4 lines down, after careful consideration of the evidence, I have no hesitation in preferring the evidence of the witnesses' call for the plaintiffs to that of the witnesses' call for the defendants. I think it is clear and more logical and more satisfactory in the treatment of the cases cited. If, therefore, the decision turned upon the evidence of these witnesses alone, I should have no difficulty in deciding that by American law, this draft was unconditional and a negotiable instrument. But there is an additional circumstance of weight, which it is necessary to consider. In the litigation between the parties in America, so the same parties, which has been mentioned, Justice Noyes, sitting as a judge of the Circuit Court of the United States for the Southern District of New York, decided on demurrer that this draft was conditional, as I have stated, but without making clear what condition existed. And it is said that this condition had been approved by the New York Court of Appeals in certain cases. And just picking it up about 3 lines on, the witnesses for the plaintiffs have given evidence that this decision of Justice Noyes is incorrect in American law and inconsistent with other authorities. The defendants' witnesses have given evidence to the contrary, and both have cited authorities in support of their respective contentions. It seems to me that we must consider whether, in our opinion, this decision was correct, and must consider it as a question of fact upon the evidence. If this were not so, evidence as to foreign law would be useless whenever there is a decision of any foreign court, judge on a point, and our courts could only follow that decision as a binding authority. This is not the position of our courts in such a matter. It may be that we have, strictly speaking, the same power to consider the decision of the ultimate Court of Appeal, but I cannot imagine that an English court would hold a decision of the final Court of Appeal in the state of New York erroneous according to the law of that state. And then Lord Justice Scruton at 1469. About halfway down the page. It will be necessary to consider both the judgment of Justice Noyes and the way in which it has been dealt with in subsequent cases, but before doing so, this general observation should be made. Foreign law is a question of fact to an English court. The judgment of a foreign judge is not binding on an English court, but it is the opinion of an expert on the fact to be treated with respect, but not necessarily conclusive. And then Lord Justice Warrington, going back to 1459, bottom of the page, I should find that the decision of Justice Noyes through an item of evidence entitled to great weight is not sufficient to outweigh the massive evidence on the other side and ought not to alter the conclusion to which but for it I should come. So I'll just go back to 1446 in Pickford. Picking it up 2/3 of the way down. There still remains, however, the important question upon which Mr. Justice Belhash decided against the plaintiffs, that is whether the judgment of Justice Noyes has been approved in the New York Court of Appeals in Springs and Hanover Bank, and in the decision of the United States Circuit Court of Appeals in granting a new trial in this case. If that be the case, I should, as I have said, feel myself bound to take it as an authoritative statement of the law by the highest tribunal in the state of New York, and should not feel myself at liberty to question it in an English court. Can I just show the court Briggs, because that may also be helpful. And Briggs, you will find at volume 5 of the authorities bundle, tab 45 at page 2857. paragraph 338, page 2857. Picking it up at paragraph 338, 2857. So far as concerns the questions which tumbled onto the page in the preceding paragraphs, it is sensible to accept that there are few decisive answers to any of them, save that the aim of the exercise of proof of foreign law should be to work out what the Court of Final Appeals in the country concerned would be likely to give as its answer. This allows a court in an appropriate case to find that though there is low authority pointing in one direction, there is good reason on the evidence before the judge to conclude that at the highest level, a court would not be bound to compound the error of the courts below.
I question whether that is actually what the real issue is. The December decision isn't a judgment of a first instance court. It's not a statement of Portuguese law. It's an administrative direction which it's agreed is binding in Portuguese law. There's no dispute about that. The effect of which is that, as you would say, until set aside, the assets are to be treated as never having been transferred. I mean, this is an administrative direction. It's not a general proposition of Portuguese law.
With respect, I'm not sure why that helps, my learned friend, but if you go back to Article 3, which is the way in which Article 3 of the Reorganisation Directive, bear in mind that we're dealing here with an attempt to get this in by indirect means, by saying that the December decision constitutes the effect that Portuguese law gives to the August decision. In other words, we're looking at this at this stage of the argument on the basis that the reorganisation measure, that's the August decision, shall be applied in accordance with the laws, regulations and procedures applicable in the home state. If my learned friend wants to rely on Article 3, he has to say that that is what the December decision constitutes. Now, once we're at that point, this may be the point that my Lord is putting to me, we say, as my learned friend said below, he used the analogy of a first instance decision of a Portuguese court, and he said you'd be bound because that's what the first instance court says. That is plainly inconsistent with guaranteed trust. I think what my Lord is putting to me is the position different because it was a decision by an administrative body?
Well, they're both,
on a question of fact.
They're both administrative decisions. Both the August and December decisions are administrative. They have the effect that they purport to have, which is binding as a matter of Portuguese law. It seems to me extraordinary to suggest that the fact that an administrative act is open to judicial review means that its effect, while it is in force, falls to be disregarded by an English court, notwithstanding that they're required to give effect to Portuguese law.
With respect, it is not that you're required to give effect to Portuguese law. We're giving effect to the August decision. And we're giving effect to the August decision in a particular way, which it is said is determined by the December decision. Now, the question is, when we are trying to give effect to the August decision, does the December decision conclusively reflect the way in which Portuguese law gives effect to the August decision? Because if it doesn't, and if in fact on the evidence before this court, it doesn't properly reflect the way in which Portuguese law gives effect to the August decision, then you don't take that into account.
But except one comes back to the time point, doesn't one? We're talking about the position at a particular moment in time when the proceedings were issued. And if, contrary to the position in guarantee trust, there had been a binding decision of the American courts, then it's difficult to see how the British courts could simply have ignored that. Similarly here, if there is a binding December decision by an administrative authority, as at that time, it's difficult to see how we can simply say it doesn't exist as at that time, because it may later, too late for the purposes of these proceedings, and hasn't happened yet, be set aside.
No one is saying that the decision isn't binding. It plainly is binding on the parties under Portuguese law. The question is whether it represents the effect that Portuguese law, as a matter of Portuguese law, gives to the August decision. So the question of whether it's binding is not one that we're asking.
Do you accept, do you, that insofar as it is binding, let us suppose it was a decision which had been affirmed at in the highest Portuguese court, do you accept then that you would be unable to bring the present proceedings?
Absolutely, because if it were upheld in the highest court in Portuguese law, in Portugal, then it would plainly represent the way in which Portuguese law gives effect to the August decision.
I see. Well,
But if it's the position that, in fact, on the evidence before the English court, it will be overruled, then the question is whether your lordships and your ladyship are bound to treat Portuguese law as represented by a decision which is likely, on the basis of the evidence before you, to be overruled by a Supreme Court in Portugal, so that it will never have represented Portuguese law, because that would be the effect of the overruling. It will, once you get rid of the December decision...
But I mean, this could be said, this could be relied upon. You can't say in domestic litigation, can you? Look, I've lost in the Court of Appeal, too bad, I believe I shall win in the Supreme Court, and therefore I'm going to ignore the Court of Appeal judgment. Well, why is this any different? You've lost in Portugal for the moment. Why isn't it binding pro tem?
It's undoubtedly binding on the parties in Portugal. The question is
whether,
for the purposes of recognition by the English court, it's a different question.
If I can be pejorative, it's again with conflict of laws point.
It's a conflict of law point. It's a completely different question. It is binding on the parties in Portugal. The question is whether it represents Portuguese law in terms of the effect that is to be given by the August decision. And if you're dealing with a defeasible decision where, on the basis of the evidence before the English court, that will be overruled, it is difficult to see how that decision can represent the effect that Portuguese law gives to the August decision. It's binding in Portugal, but it doesn't give rise to a res judicata. And just coming back to why we say it will be, if you apply the guarantee trust principle, you will arrive at a situation in which you do not regard the December decision as determinative of the effect that Portuguese law gives to the August decision. Again, and I'm sorry to repeat it, but it is important for the guarantee trust analysis. On the basis of the evidence before the English law, the Oak liability was transferred. And that is the only thing that the December decision decided. And if you have regard to the evidence before the English court, and it's not being challenged, if that is the position, the only conclusion the English court can come to on the basis of that evidence is that the December decision will be overruled. Now, I ought just to deal with this point. My learned friend, Mr. Salter, says, well, you don't know that it will be overruled, even if it is the position that you're right, and on the basis of the evidence before the English court, it is wrong. That simply, it doesn't tell you that it will be overruled. He points to the fact that Mr. Justice Hamlin, when he identifies the various agreed propositions of Portuguese law, identifies the fact that there is a power to overrule unlawful decisions. With respect to Mr. Salter, this point genuinely goes nowhere. Number one, on the basis of his own expert evidence, if the December decision is based on a wrong fact, it is unlawful. Number two, if a decision is unlawful, it will be overruled and annulled. Now, and I'll give you the references to his expert in a moment, but if that is the position, then it is, we would respectfully submit, very difficult to see why, if we're right on the facts and facts before the English court, this will not be overruled. I've suggested Professor Moreira, his expert, says certain things. That's at paragraph 8.4, 11.3 and 11.5 of Professor Moreira's first...
Tell me, what is it which entitles you here in England to say that the December decision is wrong when you would be bound by it and couldn't say that in Portugal? What is it in private international law that leads to that conclusion?
Well, in terms of the position here, there's no res judicata, so there's nothing wrong with someone saying that does not properly represent Portugal.
There's nothing wrong with you saying it in Portugal, but nonetheless in Portugal you'd have to accept that it was pro tem binding. Because
in Portugal, what the court is doing, the exercise is different.
Yeah.
The exercise that this court is doing is trying to determine what effect the law of Portugal gives to the August decision.
Yeah.
And as I say, if we're right and it is ultimately overruled, the law of Portugal would never have given effect to the August decision. That is not what
the
the
difference
Portuguese...
between an administrative act and a first instance judicial decision is that if a first instance judicial decision enunciates a proposition of law which the Court of Appeal says is wrong, the position then established is that the proposition of foreign law will always have been wrong. If you have an administrative act, the position is different, because the administrative act is valid. It's not a statement of the law, it is a direction as to what you yourself describe as a fact. And the agreement between the parties is that the parties' rights or obligations under Portuguese law are as stated unless or until a decision is annulled, exactly as the position would be in relation to an administrative act which was subject to judicial review in England.
Well, that is subject to this difficulty, my lord, that we know on the basis of Portuguese law that although it has an effect until set aside, in the same way as a first instance decision has an effect until set aside, once it is set aside, it is annulled and it never had effect. And to that extent, whether you're asking about the law or the effect of a regulation or the effect of a procedure on the August decision, one is in exactly the same position. And I say that because on each occasion, my learned friend is trying to rely on Article 3.2. And he's saying this is the way in which the Portuguese law, procedures, regulations gives effect to the August decision. Now that is either right or wrong. If in fact the Supreme Court says the December decision is wrong, then it never gave that effect to the August decision. So the fact that one is dealing with an administrative decision rather than a court decision, in our respectful submission, does not change the analysis at all. Nor does the fact that it is binding, because the exercise that one is on of trying to identify the law of Portugal is not affected by whether it's binding or not, in the same way as it wasn't affected by the fact that in guaranteed trust it was binding on the parties. It doesn't mean that the exercise that the court has to conduct in trying to identify what effect the Portuguese law gives to the August decision is exactly the same, and in essence involves trying to predict what the final Court of Appeal in Portugal will say.
I think, as Mr. Rabinowitz said what he said, because of the fact that in guarantee trust is binding on the parties. The whole point in guarantee trust was that the decision wasn't binding on the parties.
Well, under New York law, they were, until it was set aside, that represented the state of New York law. In exactly the same way as here, until set aside, it represents the state of Portuguese law. But once set aside, once overruled, it never did represent the state of Portuguese law. But thank you, Mr. Howard. So that is what we say is the effect of guaranteed trust. Now, my learned friends identify a series of arguments which they say means that the guaranteed trust principle shouldn't apply. And perhaps I can just very quickly identify for the court what they are. The first point that is made is the suggestion that, and this is Mr. Howard's point, he says the December decision is the law, not merely evidence of the law, because it is binding on the addressees. Now, to some extent, I've already addressed that. With respect, we don't know what he means when he says it is the law, not merely evidence. Of course, in this jurisdiction, where your job, having been told by Article 3 that you have to apply Portuguese law, is to try and work out what Portuguese law is and what effect it gives to the August decision. It doesn't matter whether it's binding or not. You are still trying to identify what effect Portuguese law gives to the August decision. And that is determined by the ultimate appellate court and what it says about that factual question, which, as I say, is the same factual question which is before the English court. That's the first point they make. The second argument that is made is that it is said that applying guaranteed trust in the circumstances of this case is inconsistent with Article 3 and with the Court of Justice decision in Kepler, because, so it is said, on the appellant's approach, different effects, it is said, would arise from the August decision in English law than would arise in Portuguese law. And with respect, that is to completely misunderstand guarantee trust. The whole purpose of applying guarantee trust is to ensure that the same effects are given in English law as are given in Portuguese law. And just because there is a decision which is wrong at first instance does not preclude the English court from giving the August decision the same effect in English law as it does in Portuguese law. So guarantee trust is the mechanism that, as a matter of procedure, English law uses to ensure that it doesn't give a wrong answer to the question, what is the law in a foreign state? It doesn't give an answer determined simply by a decision at first instance, which on the basis of the evidence before this court is wrong and likely to be overruled. The second point to note about the suggestion of our approach would mean different effects would arise from the August decision in English law as would arise in Portuguese law, is a point I've already made. The court will bear in mind that once the December decision is overturned, then it will always have been the law in Portugal that the December decision did not give any effect to English law, to the August decision. And to that extent, the effects given to the August decision in both legal systems will be identical. Once you get rid of the December decision, once it is annulled, the only decision that stands is the August decision. To the extent that there is any inconsistency, that inconsistency, therefore, is only temporary. It is not a consequence, moreover, of the English court simply disagreeing with the defeasible decision, but it is rather because of the fact that the English court considers that the Portuguese Supreme Court is likely to disagree with and set aside the defeasible decision. In other words, any temporal inconsistency is simply a consequence of the English court trying to ensure that there is in fact no ultimate inconsistency between what English law says Portuguese law is and what Portuguese law actually is. The second point to make about this point which my learned friends take is that there is nothing in the language of Article 3 that suggests that the procedural rules apply to ascertain what foreign law is need to change just because one is obliged to apply that foreign law by the resolution directive. I don't think it's suggested by my learned friends at all that if you are obliged to apply foreign law because of a choice of law provision, guaranteed trust would apply. All Article 3 is doing, as I submitted at the outset, is providing a choice of law provision which says apply Portuguese law. Ordinarily, the way in which the English court would apply Portuguese law is by reference to the guaranteed trust principle. There is nothing in Article 3 which says you shouldn't do that. Moreover, as I've already submitted, in Kepler, the Advocate General says precisely that you should apply your local procedural laws to ascertain what the foreign law actually is. It would be very odd, with respect to my learned friends, if the content of a foreign law changed simply by reference to what it was that gave rise to how it was that the choice of law determination was made. Why should Greek law differ depending on whether you're obliged to look at Greek law by reference to a choice of law provision in a contract or because of what Article 3, our European regulation, says? In either case, you'd expect the content of Greek law, and indeed the way in which you go about ascertaining Greek law, to be identical, unless there was something somewhere which said don't do that. As I say, there is nothing. On the contrary, Kepler says that is exactly what you should do.
So why does that point arise? I mean, it seems to me there's not an argument about how you ascertain Portuguese law. It's an argument about what is Portuguese law for present purposes. What are we looking at?
Indeed, but what is Portuguese law? Well, in order to know what is Portuguese law, there has to be a rule by reference to which you determine how do you ascertain what that Portuguese law is.
Obviously, you can't look at things other than through your own eyes, but...
Well, with respect, we're dealing with foreign law, so we know that it's treated as a question of fact in the English court.
Right.
And when you are dealing with foreign law, which you treat as a question of fact, and you want to determine what that foreign law is, the common law principle identified in guaranteed trust applies to the English court. And that is so whether or not the reason you're applying the foreign law is by reference to some European directive or by reference to some choice of law provision in a contract. That's the only point I'm making. And as I say, one of the key points that the court will want to keep in mind here is that neither Bank of Portugal nor Novo Banco at any stage identify any alternative to the application of the guaranteed trust point. If the alternative is that the feasible decisions are binding, then the English court is giving effect to what ex hypothesi is the wrong answer as a matter of Portuguese law. And there is no possible basis on which the obligation to give a decision the effect it has under Portuguese law can require the English court to give an answer that is more likely than not to be the wrong answer as a matter of Portuguese law. And this may, to have this in mind, be irreversible in certain circumstances because it would, or at least could, constitute a res judicata as a matter of English law. So this, and your Lordship and your Ladyship will recall that this is a point that Briggs makes. He said it would be incredibly unfortunate if the English court were bound to give, when looking at foreign law, an answer which it considers and knows will not be the right answer as a matter of foreign law. That's why he supports the guaranteed trust principle. And just to be clear, what my learned friend purports to be concerned about is divergence. That is to say, you could have one approach to Portuguese law, one conclusion about the Portuguese law effects in this country and another approach in Portuguese law. We are not dealing here. The only way in which you could eliminate any divergence was if what this directive included was a jurisdiction provision which said all determinations as to what Portuguese law is should be made by the Portuguese court. There is no provision like that in this contract.
So there's the next best thing. There's a provision that all foreign EU countries should align themselves with the effects which Portuguese law would give.
Indeed.
It seems to me your interpretation, since it's common ground, that if you went to litigate in Portugal now, at the moment, you would lose. You would it would be said, sorry, we can't accept that there's been a transfer. Your proposition is that we should introduce a divergence between the position in Portugal and the position in every foreign country, which on the face of it is in conflict with Article 3.
With respect, my proposition is that divergence of the sort that your Lordship is identifying is inevitable if you don't have a jurisdiction provision. Take a situation in which there isn't a decision of the Portuguese court, and an issue which is similar arises both in the English court and the German courts. Now, in the English court, the way in which we'll try and ascertain what Portuguese law says is by reference to guaranteed trust principles or whatever other principles we rely on. The German court might have a different procedure following Kepler to identify what Portuguese law is. They may well come to different conclusions as to what the Portuguese law effect is. There will be divergence, and both countries will have sought to conduct themselves entirely in accordance with Article 3. So there is nothing in the context of...
You're introducing a different divergence. Of course, different countries, because we're all imperfect, can arrive at different conclusions as to what Portuguese law is. But your submission is that it's clear enough what the position would be in Portugal, but applying private international law rules and applying the directives, it is different in other countries.
And the proposition is simply to illustrate the fact that the fact of divergence does not suggest a non-compliance with Article 3. The non-compliance with Article 3 arises because each court is going to determine for itself what Portuguese law is.
No, on the contrary. I mean, assuming all the courts, so let us assume, which is the ideal of private international law, that Germany, France, Britain, England, Scotland all get the same answer because they apply similar private international law rules. Nonetheless, your proposition is that they should all come to a different answer to the one which would pertain in a Portuguese court if you were trying to argue there that there had been a transfer by the August decision.
With respect to, my Lord keeps putting to me, we should come to a different answer to the answer that Portuguese law comes to. The whole point of guaranteed trust is to ensure that you come to the same conclusion that the Portuguese law comes to.
Ultimately, yeah.
Well, ultimately,
but I'm talking about the moment.
All right, I don't want to get hung up on. Well, at the moment, that's right. But with respect, the proposition that your Lordship is putting to me, and indeed the proposition for which my learned friends have to contend, is that this court should give effect to a decision which it knows to be wrong, and a wrong statement of what Portuguese law is in terms of the effect it gives to the August decision. In my respectful submission of the unattractiveness of submissions, that one wins hands down. Because that cannot be what the European directive requires. What happens when the Portuguese Supreme Court eventually overrules the December decision? We will have lost jurisdiction on the basis of a decision which was wrong and which we on the basis of the evidence before us, we knew was wrong. With respect, that cannot be where the directive tells us to land up.
But can I move it sideways for a moment to a slightly different sort of decision made in Portugal, which needs implementation straight away, but there's an appeal pending in Portugal. This court's asked to implement it. It's effective in Portugal, and it's said in Article 3, therefore, to be effective throughout the community. Has this court then got to work out, to hear the appeal, to see whether the Portuguese court's going to overturn it?
No, this court will, I think my lady's putting to me an example where you have a decision as to...
That needs implementation.
That needs implementation, and the challenge is to the decision itself.
Yes.
Will this court hear the appeal? No. This court will hear evidence as to what it considers is likely to happen on the appeal. That is to say, it will hear
notwithstanding that it's effective in Portugal and it has to be effective throughout the community when that's the case.
We say that that is precisely what this court is going to have to do, because this court will have to give the effect to the decision that Portuguese law says it should be given. And although, again, I'm just going to repeat what the Guarantee Trust says, you are not bound by first instance decisions which are defeasible. You have to, when trying to find what Portuguese law is, try and predict what the ultimate Supreme Court decision will say about the effect of that first decision.
Now, you say Article 3 is only a choice of law clause, but Article 3.1 refers to the empowering of the judicial authorities to decide on the implementation. If you go back to recitals 6 and 7 to see what the directive's getting at, they say the administrative or judicial authorities of the home member state must have sole power to decide upon and to implement the reorganisation measures provided for in the law and practices in force in that member state. And 7 says it's essential to guarantee that the reorganisation measures adopted by the administrative or judicial authorities of the home member state and the measures adopted by persons or bodies appointed by those authorities to administer those reorganisation measures, reading short, are effective in all member states. Would that not perhaps suggest that Article 3 is doing more than simply stating a choice of law?
My Lord is, with respect, correct about Article 3.1. Article 3.1 is very clear in saying that the only person who can decide on implementation measures is the home member state. The debate, and I should have been clear about this, is really about Article 3.2. I
appreciate that, but it talks about deciding on and implementing those measures.
And the only court which can decide on the the only state which can decide on the implementation of those measures is the Portuguese court.
Yeah, well,
but in terms of, is the Portuguese administrative authority.
Well, yes, I mean, exactly what's happening here is that the Portuguese central bank has said this is how it is to be implemented until somebody sets aside the current decision.
And I entirely accept that. Well, there is an issue as to whether that is what they're saying, and I think Mr. Lord's going to address that. That's the second of the points. But the question of whether this is effectively what they're saying, if the suggestion is that that is the way by which Portuguese law gives effect to the August decision, and if it is the case that that does not represent the way in which Portuguese law gives effect to the decision, because that is not a valid decision, in a sense we come around full circle. You're not to give effect to that, because that is not, in fact, the way Portuguese law gives effect to that decision. I think I've said all I can about that.
Yes, you're getting, time is moving on.
Time is moving on. Just to identify a third argument, which is made by my learned friend. My learned friends say that guarantee trust is effectively an invitation to the English court to find that a foreign administrative measure is invalid under its own law, and that would be inappropriate. But with respect, we're not inviting you to do that at all. We're not inviting this court to sit in judgment on the December decision made by the BDP. We're saying the function of this court in trying to understand what Portuguese law is to anticipate and predict what the final Court of Appeal in Portugal will say. That is not that you're declaring invalid or being asked to declare invalid what the December decision says. The final decision, the final objection which is made, final point that is made by my learned friends about the guarantee trust point, is to say that it gives rise to anomalies because it allows the English court to go behind a decision, even of a foreign Supreme Court, and that, it is said, cannot be right. With respect to my learned friends, the proposition that they advance is wrong as a matter of English law. It is not open to this court, as a matter of authority, to go behind, in trying to ascertain what a foreign law is, a decision of a final court of appeal in the foreign
Well, I wonder.
There is
I mean, there are,
authority.
if one concluded that it was induced by fraud.
Well, even then, I wonder.
Well, I wonder. We had a case from a Central Asian country in the Privy Council, which touches on these things, came from the island.
Well, subject to that sort of case, where there may be public policy reasons why you would. In the general run of things, which I think is what my learned friends are suggesting, they're suggesting this is an anomaly which means you don't have to even accept what a final court of appeal says. Leave aside the fraud type cases. My Lord Mance will therefore be familiar with the authority, given his familiarity with this. There's a case called Bankers and Shippers in the House of Lords, which is in the Authorities Bundle, Volume 1, Tab 4, beginning at page 1415, which makes it clear as a matter of English, very high authority, that you do give effect to the decisions of the highest court in the foreign.
Yes. No, I mean, you're obviously right as a general principle on points of law.
I just finally, I think, before I sit down, and I'm going to let Mr. Lord deal with the second point we make as to why the guarantee trust, why December decision doesn't trigger Article 3. It's been said by my learned friend that the guarantee trust point is not open to us, and there are three grounds which are identified. Can I just quickly say why my learned friends are wrong about these? The first ground that they identify, they say that the guarantee trust point is not one that comes within the scope of the grounds of appeal. With respect, that's completely wrong. Can I just give your lordships and your ladyship the references, because I won't have time to take you to this. If your lordship and your ladyship look at the grounds of appeal, Call 1, Tab 1, page 31.
I'm sorry, I didn't hear that.
Sorry, Call Bundle 1, Tab 1, page 31. Paragraph 33. Ground of Appeal 1.
Right.
The court sees that 33.1, Court of Appeal it says, in concluding that the obligation under Article 3 of the Reorganisation Directive to apply reorganisation measures in accordance with the law of the Home Member State meant that the effect of the August decision was to be determined by the effect in Portuguese law of the later December decision, irrespective of whether the December decision was itself a measure which was to afford recognition. Now, it is true that the guaranteed trust point is not explained or foreshadowed by this ground, but it is certainly covered by this ground. If we are right about guaranteed trust, then this ground will have been satisfied. And indeed, as the court will know, in the Court of Appeal, where one is required to identify grounds, one isn't entitled, or one isn't supposed to identify the reasons why that ground is covered, and that is CPR Practice Direction 52C, paragraph 5.2. So we say it's certainly covered by that ground, even if not foreshadowed. The next...
Well, I must admit that the parenthesis, or irrespective of whether, was what I thought you were going to run, but doesn't seem to be the primary basis on which you're putting it now. In other words, I think I read your submission on Article 3.2 as being primarily that you're applying a reorganisation measure in accordance with the laws, regulations and procedures of the home member state, but the laws, regulations and procedures themselves have to be part of or be a reorganisation measure. That is
certainly one of the
one of the ways you're putting it.
The ground I'm developing is that the December decision is not capable of representing the law
Yes.
of Portugal. The second ground of objection which is identified is it's said that we didn't run this point before Mr. Justice Hamlin or the Court of Appeal. Now, the reason we didn't run the point before Mr. Justice Hamlin, the guarantee trust point, is because it was irrelevant. The Article 3 point was not taken by Mr. Salter at first instance at all. It only emerged, and it emerged at a very late stage in the Court of Appeal when Mr. Howard intervened, I think about 3 weeks before the Court of Appeal hearing. Now, it is true that Mr. Howard ran that point in the Court of Appeal, but what we're dealing with is a pure point of law. And although we didn't run it in the guarantee trust point before the Court of Appeal, as I say, that is largely due to the fact that it was raised at a very late stage, and no one had the opportunity to really think through precisely what the implications of Mr. Howard's point was. The third suggestion is that the point we're running, the guaranteed trust point, is inconsistent with paragraph 50 of the Statement of Facts and Issues. And that is a paragraph which says that we accept that the validity of the December decision as such. And with respect to my learned friends, we do accept the validity of the December decision as such, as a valid administrative decision, unless and until set aside. And we are not inviting the English court to form any independent view about the validity of the December decision. We're simply inviting the court to predict what the Portuguese Supreme Court is likely to hold.
Because your argument is the December decision is not the right point of focus. We've got to focus on what the position ultimately would prove to be. And you accept, I noted it down, I just want to get it clear, you accept that if the decision had been upheld in the highest Portuguese court, that would be the end of the matter.
That would be the end of the matter.
But it is because it is a temporary decision, proudly so, that it isn't. And ultimately, that's critical to this case, that argument.
That is the issue.
Yeah.
Finally, I just need to say this. My learned friend, Mr. Salter, in relation to what we say is a pure point of law, suggests that there is a prejudice. And the prejudice that he says arises by allowing us to run this is he says there wasn't an opportunity to fully explore the evidential position as to whether the Supreme Court would be bound to overrule the court at first instance, the December decision. That is at paragraph 120.4 of his case, whether they would be bound to. With respect, the question isn't even whether they would be bound to, but whether it's more likely or not than not that they would. And in terms of whether or not there is sufficient evidence, I said earlier that if the court needs to see the evidence from a learned friend's own expert, Professor Moreira, paragraph 8.4, 11.3, and 11.5.
Sorry, you're rattling ahead.
I'm so sorry, but I'm...
Yeah, you're short, but just say it more slowly.
8.4,
yeah.
11.3, and 11.5 of Moreira 1 makes it clear, this is my learned friend's own expert, that if it is found that the December decision is based on a wrong fact, then it was an unlawful decision. And if it is an unlawful decision, then it will be annulled. It says that in clear terms. That's Core Volume 4, Tab 36, page 936 and 943. And it's not clear what further evidence my learned friend has in mind. But if there is further evidence, and it's not before the court, then with respect, the fault for the absence of that evidence rests entirely with my learned friend, Mr. Salter. Because if he wanted to run the Article 3 point, he should have raised it before Mr. Justice Hamlin, and it would have been fully covered. This point would have been fully covered in the evidence that was produced by the experts before Mr. Justice Hamlin. By the time we got to the Court of Appeal, it was too late to put in any further evidence. As I say, we don't see what further evidence is necessary, but if there is some further evidence that my learned friend has in mind, with respect, and it's not clear what it is, then the absence of that evidence is entirely down to him. He also says that because of this, he would have taken the point of, he would have appealed the September 2015 point, i.e. he was denied permission to rely on it. He says he would have appealed it. With respect, that is, not only would it not help him in relation to this point, but it was his decision not to appeal that. And it's difficult to see how I can try and attribute that decision to anything we have said or not said. My lords, my lady, that is all I was proposing to say about the guarantee trust point. We do have a second point, which is what we've called the conflation point, which is that the point that my Lord Mance referred me to, which is that even if the December decision can properly be said to represent Portuguese law, the December decision is not the way in which, on the evidence before this court, Portuguese law implemented or gave effect to the August decision. We have dealt with that in our written document, paragraph 74 to 83, core volume 1. 74 to 83, core volume 1, tab 9, page 209 to 213. And the key point, and I will sit down in a moment, I'm terribly sorry. The key point there is to have in mind the question that this court has to ask itself is not what does the Portuguese law say about who is the oak, with whom does the oak liability reside. The key point that arises there is what Portuguese law says is the effect of the August decision. And it is only to the extent that the December decision is a decision that purports to, or involves the exercise of a power intended to implement or put into effect the August decision, that it could ever be relevant for the purposes of Article 3. Now, with much regret on my part, I'm going to have to yield to Mr. Lord. I do apologise.
Yes, what about your junior, Mr. Kaplan? Nothing? Thank you. Right. Yes, Mr. Lord.
May it please your lordships and your ladyship, I'll endeavour to make what I hope will be submissions that complement those I've learned from Mr. Rabinovitz. Given the overlap between our cases, we rely upon his oral submissions, which we gratefully adopt. We, of course, rely upon the contents of our written case and the details set out therein, to which I cannot do justice in the time available, but I obviously rely upon the points that are set out therein. May I first make a Plums and Duff submission, if I may, which in my respectful submission deals with an important point, which is the sanctity of an EU scheme transfer. And your lordship will have seen that a fair bit of the Novo Banco's criticism is that my clients are seeking to have the plum of a transfer without the duff of the December decision. And your lordship will have further seen that Mr. Justice Hamblin found in his judgment that this was a plums-only decision, the August decision. Now, the reason why that is important in my respectful submission is because one needs to understand how vital respect for a scheme transfer is to this EBRRD European Union rescue scheme. And that is why it is important, where you have an otherwise valid transfer of a contract thereunder, that anybody coming along afterwards claiming to dislodge that otherwise valid scheme transfer can demonstrate that such dislodgement or suspension is something that has properly been carried out and, importantly, is to be given effect to under the European scheme with its universal recognition. And this is the crucial reason in my respectful submission why one looks, in this case, through the telescope, starting with the August decision, and not, as the respondents would have it, starting with the December decision and looking backwards. To make good that submission, may I respectfully refer your lordship to some aspects of the EBRRD to which you weren't taken earlier. Could I just, in the authorities bundle, volume 1, behind tab 2, if your lordship would be kind enough, please, to turn up paragraph 1232, sorry, page 1232, your lordship will see the recital start at that page. And can I just respectfully draw your lordship's attention to recitals 3, 4 and 5, running over to page 1233, and emphasise the importance of stability, but particularly continuity in the context of the financial markets generally. And can I please then next go to Article 31, which is at page 1290, Authorities Volume 1, Tab 2, page 1290, where your Lordship and Lordship will see resolution is set out, and Article 31 sets out resolution objectives. And Article 1 requires resolution authorities to have regard to the resolution objectives, and then those are set out in Article 2, and they include 2A, to ensure the continuity of critical functions, B, to avoid a significant adverse effect on the financial system, in particular by preventing contagion, and so it runs on. And if one could go, please, then, to Article 34 at Authorities 1, Tab 2, page 1293, one can see that there are some principles laid down governing resolution under this EU scheme. And importantly, one sees in F and I that, picking it up at Article 1, Member States shall ensure that, when applying the resolution tools and exercising the resolution powers, resolution authorities shall take all appropriate measures to ensure that the resolution action is taken in accordance with the following principles. Little f, except where otherwise provided in this directive, creditors of the same class are treated in an equitable manner. And little I, resolution action is taken in accordance with the safeguards in this directive, which we would say double underline. And if one goes, please, to Article 37, 9, at page 1299, one will see that under the section of Article 37 dealing with resolution tools, Article 37.9 says Member States may confer upon resolution authorities additional tools and powers, when provided that, and then little b, they are consistent with the resolution objectives and the general principles governing resolution, referred to in Articles 31 and 34, to which I've just taken, Your Lordship and Ladyship. Your Lordship has been taken to Article 4, which deals with the Article 40, at Authorities 1, Tab 2, page 1303, which deals with the bridge institution tool with which we're concerned in this case. In other words, the transfer from a bad bank to a good bank. And Your Lordship will see on the restraints that are contained within this bridge institution article, in Article 40, and you've seen those in Articles 6 and 7, at page 1304, and just emphasising that it's not open to a resolution authority just to transfer back to the bad bank if it feels like it, or if it chooses to exercise its administrative discretion in that regard. There are RRD scheme restraints, express restraints, on a transfer back, in effect, to the bad bank. And that's obviously an important part of this bit of the rescue scheme. And further, in Article 40, subparagraph 8 of page 1304, there's a reference to the safeguards. Transfer should be subject to the safeguards referred to in Chapter 7 of Title 4. And for your Lordship's note, but I don't suggest you have to turn it up now, that starts at page 1343 of this tab. And there are a series of safeguards set out therein. And in Articles 9 and 10, so subparagraphs 9 and 10 of Article 40, your Lordship will see the importance of continuity being achieved as a result of the exercise of a bridge institution tool. And finally, if one goes to Article 6, to which my friend Mr. Bennett took you to, at page 1338, your Lordship has already seen that this EU scheme provides its own specific provision enjoining Member States to give effect to an EU scheme transfer. Now, my Lord, I'll just put that away for...
Sorry, what was that? That was Article 6?
My Lord, that's Article 66...
Right, which one?
Article 66.1, and then Article 66.3 has restrains interference with a transfer. Okay. Now, my Lord, the reason it's important to understand the plums and duff analogy, and why Mr. Salter's submission is bad in that respect, why Mr. Justice Hamblin, as he then was right in his analysis, is to understand that the plum, an EU transfer plum, is not just a plum in the hand of the creditor, who is now facing the solvent good bank. It is an important bit of fruit and vitamin C, as it were, under the European scheme. Because for this to work, for this European scheme to work, which is plainly aimed at the sort of systemic, systemic problems that can arise in the markets, it's envisaging as far as possible, a seamless transfer of the business of the bad bank to the good bank with a sort of business as usual carrying on thereafter. And the reason that makes a scheme transfer a plum is because this rescue scheme, this European rescue scheme, to maintain financial stability in the whole European banking sector, critically depends upon respect universally being given throughout the member state courts to a transfer that is otherwise a valid scheme transfer. Because if that is not the case, if a scheme transfer, or rather a transfer of all the business of the bad bank, if all those market participants can't trust that that scheme transfer is going to be respected and not dislodged in some quixotic and incompatible way, it's important that all the member state courts, including England, give proper effect to that transfer, that EBRRD transfer. And that's absolutely crucial. And that is why this is not a case of plums and duff.
If you'd suffered some prejudice, if you'd, or somebody else had, if somebody else had bought the debts from you, they might have a big complaint, and it might be impossible to maintain the December decision in that light. But I've seen no suggestion that you were in any way prejudiced.
My Lord, the submission that I'm making makes good the proposition that as a matter of principle, one has to give proper effect to a transfer, because it's not really good enough, with respect, to direct potentially interested contractual parties into the administrative law regime, because there is no certainty of timing, the adequacy of the relief or the remedy. And the key bit of this bit of the scheme is to seek to ensure some continuity of function, which means that if your contract with the bad bank has been transferred, you are confident that subject to anything being done to it that is compatible with the scheme, you can proceed as if that is a valid transfer to the new bank. So it doesn't matter in my particular case whether there is or isn't prejudicial action on the strength of it. I'm looking now at the policy behind this scheme and the fact that it will not work if, in fact, an otherwise valid scheme transfer can be suspended or interfered with in a way that is not...
Well, how does that reconcile with the provision for retransfer of debts which appear to have been transferred but shouldn't have been? I mean, creditors and third parties are vulnerable to that sort of thing.
Well, my Lord, the important point in Article 47 is to see that it includes safeguards on the transfer. First, the prospect of retransfer has to be expressly identified. And Your Lordship is right that in little paragraph B, it envisages effectively a transfer back, we would say, where something has been transferred by mistake. But one would expect that to be the exception and not the rule. And the danger with my own friend for the respondent's contention is that would drive a coach and horses through this EBRRD scheme, because the whole point of it, it's a rescue scheme operating at a high level of market danger, as it were. And that's why, my Lord, that's why we say, with respect, that it's important to understand that the fact that the August decision transferred all these liabilities, except if they were excluded, is a critical part of the analysis. Because what that means is giving effect as the EU scheme requires to that August transfer, which is a reorganisation measure because it was a resolution measure under the August decision. So the English court has got to recognise that August decision, and that's absolutely an absolutely key part of the analysis. And if you are going to give proper recognition to an EU scheme transfer, that carries with it, by necessary definition, that you, as any member state court, will scrupulously assess any suggestion after that transfer has happened that it has been dislodged or suspended in some way. It's not an anti-EU scheme. It's a pro-Euro scheme principle, that, because otherwise the scope for interference and tinkering, to use the terminology used earlier, is endless. There've got to be some restrictions to preserve the sanctity of this transfer of the book of business, in order that all the market participants don't just sit on their hands or start. The whole point is that the thing will actually carry on in the normal way, and we say that is why the critical question here is what is the Portuguese law effect of the August decision? And it's accepted that without the December decision, the August decision would have been effective, was effective, to transfer the oak liability to Novo Banco without any further step being taken. And we say that the effect of the respondents' case is to subvert the scheme, because they, in our submission, they do not establish that effectively the suspended animation, which December purports to try to effect, they haven't established at least two things. First, that giving effect to the August decision as a matter of Portuguese law involves you taking account of the December decision. That's the first thing. And secondly, that the December decision has the effect for which they contend. Their submissions also have the effect that the counterparty to this oak contract is a will-o'-the-wisp. If they're right, it means that under Portuguese law, the debtor became Novo Banco in August 2014, stayed that way to December, then became Besh again, and then if and when a court rules on the excluded liability point in favour of the appellants, it will go back to Novo Banco again. But that's a profoundly unsatisfactory state of affairs, and again is the opposite of a seamless transfer which the European scheme requires. Further important element of this is that the evidence is that the Portuguese administrative process could take many years to run its course. And the reference is Stephen Baker's statement at Core 4, tab 44, page 1063, paragraph 36.4, could take 5 to 6 years, including appeals. So, on the respondent's case, this, if we're right that the oak liability was not an excluded liability, it means it was transferred by the August decision to Novo Banco. And Novo Banco was from that date and will always have been the debtor, the only debtor. And that would mean that if at the end of the Portuguese administrative appellate process that position is vindicated, it means that my clients would then have to sue Novo Banco under the exclusive jurisdiction clause in England, and could then be met with limitation defences because they are then out of time to sue Novo Banco. And the upshot of the respondent's case seems to be that in this debt claim against Novo Banco, which for present purposes this court should proceed on the basis is the right debtor, because we have the better of the argument that is the case, there is no civil or commercial court that has jurisdiction to hear that contractual claim. And we said that is a very surprising outcome and not one that's actually required under the English court. Under the European scheme. I'm going to have to go very quickly through some of these points. So the starting point, my lord, we say, is that the English court has its common ground. The English court would have had to give effect to the August decision, and its common ground that would be effective to transfer the oak liability if the oak liability was not an excluded liability. So then the question is, why does the December decision change that position? I'm going to Mr. Bennett has explained that there are two ways in which the respondents put their case. First, they say that December is a reorganisation measure to be directly enforced. Alternatively, that it falls to be indirectly recognised. Can I deal very quickly with the direct recognition point? Can I ask your Lordship please to turn up the December decision, which is in the core bundle 2, tab 18, and page 473, which you were taken to. And your Lordship will see, in paragraph A, the Bank of Portugal decided that the oak liability was not transferred. So it doesn't purport to be doing anything active here. It is commenting on something that happened as a result of the oak liability. And that is important because it deals with Lord Sumption's point about the nature of this administrative decision of the Bank of Portugal. It wasn't doing that. It wasn't exercising some discretion vested in it to keep the oak liability with BESH. It was simply observing what it thought may have been the upshot of the August decision. And if one goes...
you've got to read the whole of A, B and C. This ruling is effective as from the 3rd of August. It's a ruling. It's been given retrospective effect. And the account adjustment provisions follow. So it's clearly doing more than remarking on a state of fact which it understands to obtain.
Yeah.
Well, if your Lordship has Mr. Justice Hamblin looked at if you should be kind enough, please, to go to C2, Core 2, tab 16, page 441.
Yes. Paragraph?
Paragraph 90, sorry, my Lord.
90. Thank you.
The point that with respect Mr. Justice Hamlin is there making is that the August decision represented the substantive administrative decision. That was the benchmark. It was set by August. All the liabilities are transferred except excluded ones. What August was not doing, my Lord, was to add some additional ingredient by way of some extra administrative discretion or judgment. It was simply observing this alleged risk. It wasn't changing the criterion for the transfer. So there was always, despite this decision, there was a criterion set by the August decision as to whether the oak liability was or wasn't transferred. And if one goes to paragraph 99, over the page, at page 443, Justice Hamblin, with respect, makes this point really in another way. And
well, that's a bit putting it a bit low, isn't it? Simply asserted the rule serious and well-founded reasons. It's done a good deal more. It's gone on to back its hunts, hasn't it? And to say, we're going to impose on you, for the moment, the result which we think is likely to be right.
But my Lord, it was deferring expressly to a court of law. It wasn't purporting to say...
Yes, for the moment, I said. I mean, obviously it's all subject, but...
my Lord, with respect...
One thing puzzled me about the Mr. Rabinovitz's case, and perhaps you can help on this. he refers to an absence of evidence that the December decision retrospectively altered or restated the August decision, a proposition that Novo Banco initially pursued but then abandoned. But I don't know about the circumstances of the abandonment, but on the face of it, it isn't what's happening here at least a provisional, for the time being, restatement of the position, reading the two documents together. Whatever you may think about the August document by itself, you must accept for the moment that it doesn't have that effect as regards the oat liability.
Well, my Lord, the issue was, what is the effect of the August decision, and does the December decision alter the Portuguese law effect of that, which in my submission is a different question to whether the December decision is binding on its addressees as a matter of Portuguese administrative law. And there was a lot of debate amongst the expert evidence and disagreement as to what the December decision might be. There was quite a bit of agreement as to what it couldn't be, and much of that is relevant. But it also needs to look at the nature of that Portuguese law evidence debate. We in our appendix, the appendix to our written case, which is in Core 1, tab 10, page 273, we set out what we respectfully submit are the important elements of the Portuguese law dispute, which
Sorry, what's the paragraph?
sorry, my lord, it's the appendix really. It starts at page 273, and we...
Does this have a little number at the bottom?
It's... Sorry, my lord.
I'm using a loose number.
It's my fault. It's page 273, subparagraph, it's the Roman 1. It's the...
Yes, I see.
It's the back of our...
Fine. Yes, I got it. Thank you.
Sorry, the internal paragraph number is...
It's the
Roman 1, my lord. It's the appendix, but the end of our written case.
I've got the appendix.
1, tab 10, page
Yes, I'm not
273.
working from that bundle. I'm working from a loose copy. So,
Which page of the appendix?
which page
are
of the
you looking at?
appendix?
Little one.
Little Roman 1 was the...
Right.
I was only really identifying that the whole...
The first
whole,
page, right.
Yes, but the whole thing. I was just trying to locate it, my lord. I
Right.
apologise, but the reason that we took the trouble to set these disputed propositions out was because in our respectful submission that they reflect the dispute that there was as to whether, as a matter of Portuguese law, when giving effect to the August decision, you give effect to December, and that you do so in the way that the respondents now contend. Because otherwise, the mere fact that an administrative authority in Portugal has issued a decision that binds its addressees until set aside doesn't affect an otherwise valid European scheme transfer. It's important that you can't just couple those two things together in this sort of quixotic or light way. Those are important. That coupling is absolutely essential. And what was the reason that the appendix is important is because it really identifies how much of what the respondents need to slide in their submissions by way of what is Portuguese law here was not accepted or was in dispute by Justice Hamblin. Yeah, and just if we just tick through, if I can just run through some of the little a on the bottom of page 273 of Roman 1. This was the part and parcel point, and that's important because when one gets to the indirect case, one has to remember that this reading December as a necessary flip side to August was not actually pursued in the end. Wasn't actually taken forward.
Really? Well, that's the same point that Mr. Rabinowitz's case made. Where do we see that it wasn't taken forward? Have you just explained the position a little more specifically?
Yeah. Well, if one goes to... well... Well, in front of... Sorry, this is the way it was put. Mr. Salter, in front of Mr. Justice Hamblin, he said that he didn't need to require Mr. Justice Hamblin to decide some of these disputed points because he could rest on the agreed proposition. So it's fair to say that this point may have been abandoned by him, but it's right to say there was a dispute about whether December was part and parcel of August, and he indicated to the court that the court could go forward and decide his jurisdiction application without resolving that question. And there was a live dispute between the experts as to whether that was the right Portuguese law effect. And if one goes to this...
I see, so it's... Yeah, right.
Yeah. So what this appendix does, each bit of the appendix, and I'll trot through it as quick as I can, shows some important parts of the Portuguese law expert evidence that were in dispute, and relevantly in dispute. And I've made the point that the sanctity of a scheme transfer means that these aren't idle points, these aren't silly, contrived points. If you're going to say to somebody, you've lost your scheme transferred contract, you have to do it in an orderly and rigorous way that complies with the restrictions and the rationale in the EU scheme. And that's why these points were important, because it stripped away the necessary linkage between December and August as a matter of Portuguese law, quote unquote. And that's the absolutely key point. If one goes to little b at page 275, Roman 3, this was another point that was in dispute, that the Bank of Portugal was empowered under Portugal to determine the effect of its decisions. And the relevant references are there set out. And then over the page, at page 276, little c, we make the point that no specific Portuguese banking law power or even Portuguese administrative power was identified. So all that was said was, generally, an administrative authority in Portugal can issue decisions that will bind their addressees until set aside. That ultimately is the coupling here. And we said that can't be enough because that would mean that any administrative authority in Portugal could issue a decision that bound the addressees until set aside, and that would have the effect of, in effect, supplanting or dislodging an otherwise valid EU scheme transfer. And we said that just can't be right. And we've gone through, in the appendix, we've given the examples of that. We've dealt with the powers of administrative authorities at Romans 6, page 278. Gone through that. And then at page 283, little Roman 11, interpretation. Yeah, sorry. I go back to page 279. There was some debate about whether the December decision was a reformation, ratification, conversion, revocation, amendment, or replacement. And we've set out the evidence there, including, it's important to remember, Professor Moreira was Novo Banco's own expert. And then I was dealing with interpretation at page 283, little Roman 11 in internal numbering. Interpretation. Professor Moreira initially suggested that December could be an interpretation of its earlier August Administrative Act, but then he actually retreated from that. In the face of the other experts, he said at the bottom of that page that December was probably best not understood as an interpretive decision. So one could cross that off as a Portuguese law coupling of December to August. And then going over the page, importantly, in answer to some points from the bench today, page 284, Roman 12, application implementation. And there was a live debate between the experts as to whether December could properly be viewed as a matter of Portuguese law as the application or implementation of the August decision. So that was a live dispute that Mr. Salter did not press for a decision in order to make his jurisdiction challenge before Mr Justice Hamblin. And that's obviously that's a very important part of this appeal, because much of my friend's case now rests upon the assertion that as a matter of Portuguese law, December is the application or implementation, double underline, of the August decision. And that was indisputed by Mr Justice Hamblin and was not pressed to a decision by him by Mr Salter. And it can't be right that can just be brought back in now, we say. And then page 287, 15, rectification was dealt with, and then little d, it's not open to the respondents to dress up December or February as exercise of any discretion by BDP. And this is again a key point. December was not the exercise of an administrative power by BDP in the sense of changing substantively the ingredients or components of the previous transfer. They weren't adding some element which said, even if Oak is an excluded liability, nonetheless we are going to say it's going to stay with Besh. Now that one could see that whether it's valid or
not. It's not an excluded liability.
Yeah.
Yeah.
So, and that was a crucial, and Mr Justice Hamblin recorded that fact, that facet in his judgment, that was not happening. And then if one goes to little e, page 289, to Roman 12, again which is important, we say it wasn't open, it's not open to the respondents to contend that December or February finally determined, or purported finally determined, whether the Oak liability was an excluded liability. That wasn't what was happening, and they couldn't do that because they weren't a court, they were administrative authority with certain powers. And what they couldn't do, in effect, is to make some adjudication on that matter. And Your Lordship has seen that the December and February decisions, they expressly deferred to a court of law to make that ruling. And that court of law will have to decide, as a matter of the Portuguese law and fact, whether Oak was or was not an excluded liability. There's no other litmus test in play at that stage. So that's the question. So they were deferring to a court of law, saying we're going to suspend the obligation at the moment, to defer to a court of law, but that was the test. And we have the better of the argument that this was not an excluded liability, and therefore it was transferred under the August decision, and that's something which the English law must recognise under its universality obligations.
But supposing the August decision had said, these are the principles for transfer. If a dispute arises, then the Bank of Portugal has administrative power to suspend the operation of this agreement for the time being, in which event the obligation to transfer shall be suspended, and that is, of course, subject to resolution of the factual dispute as to whether the asset fell within the excluded class or not by the highest court, if necessary. Or you wouldn't have any case then, would you?
Well, my Lord, the difference then is that it's not a plums and then an attempt at duff. It's all in the same. It's all, and my Lord,
let us
that is important.
I mean, this doesn't exist in the ether. This exists as a reorganisation measure under Portuguese law to take effect and to be applied in accordance with Portuguese law. So why is it different that the administrative decision is done separately?
Well, because Your Lordship is there assuming that what Your Lordship just posited, that would have been valid under Portuguese law and would have been respected in the same way and would have had to be given effect to.
Well, and why wouldn't it?
Because there is no evidence as to that
It's accepted that the December decision is effective under Portuguese law.
Well, it's effective as a decision of an administrative authority.
And binding.
And binding it on its addressees, but it is not accepted that as a matter of Portuguese law qualifies or in any way materially affects the August decision as a matter of Portuguese law.
Well, how could it avoid doing so?
Well,
because you couldn't go to court in Portugal and say, pay me, while the December decision is in favour.
But you could. But you can go to a court of law because a court of law it was envisaged in those decisions. It was,
Yes, but you'd have to set aside the Portuguese decision first, wouldn't you?
No, my lord, the crucial difference is that if it's all part and well, once there's been a transfer, once there's been a valid transfer, then you are entitled to proceed as if there has been a transfer, and that's a different situation from saying at the beginning there has been no transfer or a conditional transfer. That is a different.
My example, my hypothesis was something which stated what would be transferred, but left open and governed, regulated the position if some issue arose. If there were second thoughts about whether something really did belong within one class or another. Anyway, I was putting to you the possibility.
Well, it would have been a question, my lord, whether that was a valid transfer under the EU scheme, because your lordship has seen, as Mr. Bridget's explained to you, that there were the checks and balances that there are in the scheme. And what Justice Hamblin said was that nowhere in the EBRRD is there this particular suspensive power.
Well, you could presumably have a scheme which said that a new bank will be set up and there will be an inquiry by a firm of accountants who will ascertain any loans which fulfil certain criteria, which will be then transferred to the new bank. So you don't have to agree everything at once, do you?
No, but then the crucial difference is that there, on that hypothesis, there may never have been a transfer. You haven't had the valid transfer,
yes,
which then is trying to be walked back. And that is important because what the market then knows is it's got to wait to see if there's been a transfer, as opposed to being told there has been a transfer, and then we say on some insufficient basis, you're then told that transfer has been suspended. And it makes a world of difference in terms of market confidence that you know with clarity and rigour what the position is at the beginning of the transfer process, as opposed to down the line, the whole thing is effectively dislodged in this way. I'm going to move on now. I haven't probably got time to go through all the rest of the appendix. We've set out what Novo Banco's case was on Portuguese law. That's at page 292 of Roman 20. And then a paragraph at page 295, we've set out what Novo Banco put in their skeleton argument by Mr. Justice Hamblin as to the Portuguese law nature of the December decision, where they accepted that there were different views as to what that might be. And my lord, so our case really very, very simply is that the August decision was the transfer decision as to the oak liability, and that will be determined as a matter of Portuguese law, depending upon the excluded liability, and we have the better of the argument on that. Nothing in December says that there should be a different transfer outcome. It's purporting to suspend, in some way, the transfer of the oak liability, but it's not affecting that transfer benchmark. And we say that the August decision is a valid, it should be given effect under English law, but that subsequent suspension should not. And we say that it's for the respondents to show why that subsequent dislodging of the transfer should be recognised under English law. And to do that, they've got to show either that December is directly to be recognised as a reorganisation measure, or indirectly. And just very quickly, I've only got 12 minutes, very quickly, in terms of the direct effect, and the friend has really dealt with that, we say that it's plainly not a transfer, the December decision. It doesn't purport to be a transfer. It purports to say, to give some opinion about what had happened in the earlier EU scheme transfer in August. We say it's plainly not a transfer. It's plainly not a retransfer either, for the reasons that my friend gave. And it's worth noting that the December decision identifies provisions under the Portuguese banking law to do with transfer of a contract or liability, but does not identify, does not refer to the Portuguese banking law provision that deals with retransfer or transfer back. And we say, and we respectfully refer to the further submissions we make in our written case at paragraph 53. The reference for that. Paragraph 53. 53 at C41/10/249, paragraph 53, we set out some further submissions on that. So we say that it wasn't a transfer or a retransfer. We say it's clearly not some other unidentified power. You've got to identify the power before you can start to suggest that should be given direct effect under the reorganisation measure framework. And we also echo Mr. Bennett's submissions about it not being an original reorganisation measure, because it plainly didn't satisfy the requirement to preserve or restore the financial situation of BESH or Novo Banco, if that were relevant, or even more generally. There's nothing in December that looks to any financial position or stability, whether of the particular institution or even systemically. There's nothing of that at all. All it's talking about is this 2% excluded liability rule. So one can't possibly elevate December into a reorganisation measure under the old definition. In terms of the indirect point, my other friends made the point about guaranteed trust. We say with respect that the right analysis is to start with the August decision, which was a valid EU scheme transfer, absent December, and then you ask yourself, does December change the Portuguese law effect? Because the Portuguese law effect, absent December, is that this was transferred if it was not excluded liability. So you have to say, well, does December change things? And the expert evidence, Portuguese law evidence, was not that giving effect to August. You have to look at December, or give December the effect that my own friends contend for. I mean, there is no real tension here between having the fact that in Portugal the administrative authority can issue a December decision doesn't mean that under the EU scheme a member state court like the English court applying English law should effectively allow that administrative decision to displace an otherwise binding EU scheme transfer that August was. And otherwise it would mean that any administrative authority could issue a decision and come along and say, well, it binds the recipients, and that somehow that has to be recognised by another member state court. And all the safeguards and all the restraints that my little friends rely upon, they all really stem from the idea that what the Bank of Portugal was doing in December was some exercise of some proper banking or other scheme power. In other words, it really lapses, their submissions endlessly slide back into an assumption of some directly recognisable underpinning of December. And we said that there were no direct underpinnings that this court should recognise, either transfer, retransfer, ancillary power, or the original preserve or restore. None of those underpinnings help December. So you then say, look at December, stripped bare. It's got none of those directly enforceable qualities. Is it right that as a matter of Portuguese law, giving effect to August, that we know is a valid scheme transfer, all things being equal, you should look at December and say, no, December changes things? The answer is why? Why should you? The whole point of the scheme is that it has restrictions and restraints. And that's why the absence of the Portuguese law evidential basis for the coupling of December and August means that Mr. Justice Hamblin was right to come to the decision he came to, given his view about the better of the argument. Because what that means is that the Portuguese law effect of the August decision, that transfer benchmark that was set down, is that this liability was transferred to Novo Banco on the 3rd of August 2014. And the fact that it will take a court of law to effectively pronounce upon that doesn't change the fact that that is the proper effect of Portuguese law on that August decision, even if in tandem you have this pro tem administrative decision by Bank of Portugal in December. So we don't accept that you can conflate these 2 points. You can't simply say, because December is the decision of an administrative authority and binding, that therefore elevates it into a recognisable measure that would have to pass through the various requirements, both within Portuguese law first, and then the EU scheme framework, before it's to be recognised by another member state court like England. And that is giving proper respect to the principle of universality, because only by that rigorous set of checks and balances do you make sure that a scheme transfer, which August was, on any view without December, that is not going to be undermined or tinkered with in a way that will be quite inconsistent with the rationale and policy behind the recovery scheme together. We don't need to challenge the December decision in this sense that the December decision is not purporting to alter the August decision. It's not purporting to change the transfer criterion that was there set out. Once that transfer criterion is properly applied to the facts by a court of law, we would hope here or in Portugal, it's going to agree with the better of the argument prediction that Oak liability was not an excluded liability. And the effect of my learned friend's contention is really that in any sort of dispute such as this, the administrative authority in Portugal has exclusive jurisdiction to decide these sorts of disputes. So you drive a coach and horses through the jurisdiction provisions in all the contracts that have been transferred. Because what it means is the Bank of Portugal will pop up and say, no, any dispute like this has got to be repatriated to the administrative court in Portugal, not even a civil or commercial court, although it's a civil and commercial claim. So what is a transferred banking contract with a jurisdiction clause, there's a civil and commercial debt claim against Novo Banco, which on this hypothesis will be shown to be and was the only true counterparty at all material times, is currently courtless. It doesn't have any civil or commercial court in which interested parties can vindicate their rights, save by going through the administrative law process. And we say that cannot be the right answer. When one circles back to Article 40, to the EBRRD, and sees all those provisions about the checks and balances and safeguards, that is simply not the right answer. And it was the respondents who chose not really to contest or not to file evidence in challenge to the submission by the appellants that we had the better of the argument that this was not an excluded liability. And it was the respondents who chose to sit on agreed propositions of Portuguese law that fought shy of grappling with whether there really was under Portuguese law the need to give December the effect for which they contend in order for the English court faithfully to enforce and recognise the August transfer. So we say that one can't criticise Mr. Justice Hamblin. He came to the right decision on the evidence before him, and that there is nothing that the respondents can point to that would dislodge that August transfer. Is there anything else? And just perhaps one final point. If one looks at the way the respondents put this the indirect case, they focus on Article 3 of the 2001 directive, which is at Authorities 1, behind Divider 1, at page... Sorry, that might be the wrong reference.
Somewhere at the beginning, anyway.
So it's my fault, my lord. It's... Yes, it is.
Page 1226.
Read for my lord. And it's at 1226, yes. And one has to bear in mind, just finally, that the August decision was a resolution measure. Resolution double underline. There was an EBRRD measure. It was a resolution measure under the EBRRD, and thus, and as a result of that route, it is recognised directly under Article 3. But that's the route that gives it recognition. And then one has to posit, well, why should some other measure of any sort come in to change things and take that transfer away or suspend it in some way? And the respondents put a lot of weight now on Article 3. And we say that however you run at this, they don't have the Portuguese law underpinnings to be able to say that in order to give effect to August, you have to look at December. There is this gap, which our appendix sets out, that means that they can't bring this indirect case home. And it would be, in my submission, unfair on the appellants, given the way the hearing, if it was Justice Hamblin unfolded, when an awful lot of Portuguese law disputed expert propositions were not ultimately pushed by Mr. Salter to any decision, for this appeal then effectively to allow him to resurrect submissions on the state of disputed Portuguese law matters, when that isn't really how this appeal has been prepared, and when there hasn't been the time to go into all the expert reports and to come into the detail that you would hope. And that's why we've sought in our appendix to identify just what very real problems he would have faced in establishing that he had the better of the argument on an awful lot of the building blocks that he would need to establish to get his indirect case or direct case off the ground. My Lord, I've obviously been very time constrained. Could I just ask, I obviously stand by what we put in our written case. If I may stop there, I'm not sure I can really develop many more submissions in the final 2 minutes. Unless I can help your Lordship further, are there any points?
No, thank you very much indeed. Does your junior wish to add anything, Mr. Plume?
No, thank you.
Right, well, we will resume at 10:30 and look forward to that.